Hi everyone, this is Nadia Phillips here representing Team Delta discussing patent applications. The first patent application I am going to discuss is the provisional patent application. Next will be the utility patent application. Contrary to what people may believe, there is actually no such thing as a provisional patent, but there is a such thing as a provisional application or provisional patent application. Under the United States patent law, a provisional application is a legal document filed in the United States Patent and Trademark Office that establishes an early filing date, but does not mature into an issued patent unless the applicant files a regular non-provisional patent application within 1 year. Here are some key facts about the provisional application. The first is that it provides an early filing date. This is basically if you and another inventor invented the same thing. Whoever has filed a provisional application at the earliest date will probably be the one to be issued the patent. The cost for a provisional application ranges from $65 to $280. We will go over the different variations of prices as we get to slide 18. Next is that it is only valid for 1 year. If you would like to continue with your idea and go ahead and file a utility patent for it, you can do so, but you must do so within that 1 year. Next is that it enables immediate commercial promotion of the invention with greater security against having the invention stolen. So by filing a provisional application, you give yourself 1 year of a little bit of protection to prevent your invention from getting stolen. The next is that there is no review or examination. So this is why it does not qualify as an actual patent. Also, it cannot be used for design patents, only utility patents. The last thing is that you have the ability to use patent pending on your idea through filing a provisional application. This will thus create a little bit more security when you actually try to market your product. Here's a checklist of the things you need for your provisional application. First, you need the provisional application papers, which basically consist of a written description and the drawings that you wish to use to describe your invention. We will discuss the drawings and the written description in the utility patent section of this slideshow. The next thing you need to do is you need to provide a provisional application for patent cover sheet. We will see an example of this in the next slide. The last thing you need to do is pay the appropriate fees. Again, we will check out the fee schedule around slide 18. Here is the provisional application for patent cover sheet. This cover sheet basically asks for basic information about the inventor or the inventors. It asks you to give the title of the invention and then other basic information. On the next page, it basically is a signature sheet so that you can verify that you are the original inventor as far as you know. The last sheet is a Privacy Act statement. Remember, with this provisional application cover sheet, you also need to provide a written description and the drawings and also pay the appropriate fees. What is a utility patent application? A utility patent application or non-provisional application is a series of documents that are sent into the United States Trademark and Patent Office to be approved. Approved applications will receive an official utility patent that protects the functional aspects of your invention and the process. Here are some key facts about the utility patent application. First, you need to know that it is examined by a patent examiner. Next, the cost ranges from $70 to $280. It protects the functional aspects of the invention, not necessarily the design of the invention. And it could take up to 2 to 3 years to receive. Here is a checklist of the utility patent application. First, you will need to have a utility patent application transmittal form or transmittal letter. Next, you will need to provide the appropriate fees. Then you will need to provide an application data sheet. You also need to provide a specification with at least one claim. You will need to provide drawings when necessary, the executed oath and declaration document, and when applicable, you must provide the nucleotide and amino acid sequence listing, as well as large tables or computer listings. Here's the utility patent application transmittal form and transmittal letter. Basically, this is like a cover sheet for the rest of your patent application. In this first form, it asks for basic information, but it also can provide as a checklist for you as you're filling out the rest of the application. Here is the Privacy Act statement that is also included with it. Next, you would need to provide the application data sheet. This is a 5-document sheet, and it consists of more information about the inventors. On the last sheet, it provides a signature page for you to verify that you are the representative of the invention. On the last sheet, it provides the Privacy Act statement once again. The next thing you must provide is a specification with at least one claim. A specification is basically a written description, and it must be clear, full, and concise. In this specification, you must include the title of the invention. You must also cross-reference to related applications. So for inventions that are similar to yours, you must cross-reference those inventions. Next, you must provide a statement regarding the federally sponsored research or development, if applicable. You must also provide the reference to sequence listing, a table, or a computer program listing in compact disc form, if applicable. You must also provide a background of the invention, a brief summary of the invention, a brief description of the several views of the drawings, detailed description of the invention, and then you must also provide a claim or claims. Basically, a claim is what you have proven that your invention can do as opposed to other inventions. The last thing you need to provide in the specification is an abstract of the disclosure. Specifications that are over 100 pages will be charged additional fees. The next thing we're going to look at are the drawings that you need to provide. Obviously, this is not a good example of a patent drawing. Here's a good example of a patent drawing. You must use drawings when they're necessary. In this particular example, they're using the example of a jewelry box. In the right side, you see that they show the actual sketchings of the invention. Typically, this would be done by a graphic or drafting company. Then you see that they have labeled each picture with the figure number. And on the left side, it gives a description of each figure. After you have provided the previous information, you also need to sign the executed oath or declaration. Basically, this is just your signature to say that you are the original owner and inventor of the invention as far as you know. Other requirements that you need, if applicable, are the nucleotide and amino acid sequence listing, and also if you are including large tables or computer listings. So what is the difference between the two? PatentFile.org compares the two to an engagement versus a marriage. A provisional application is like an engagement. You have not officially received a patent, but you can use the term patent pending, just like an engagement ring. The next thing is that it only lasts 12 months. This is around the same length of time that most engagements last. Also, you have a choice to move forward or to drop the idea. Similarly to an engagement, You can either move forward with the marriage or you can call it quits. A utility patent is like a marriage. You put a patent number on your product as proof of your patent. This can be the same as a marriage certificate or a wedding band. Also, with a utility patent, it lasts for 20 years and then you have to renew. Now, marriage, you don't have to renew, and typically you want it to last a lifetime, but they compared the two anyway. And next, your patent has been officially granted and no one else can take your idea. This is similar to once you marry your girlfriend or boyfriend, they are officially off the market. Small entity versus micro entity. Basically, depending on the size of your business, you may be able to file under micro status or under small entity status. This means that you can be discounted up to 75% for the fees that are required to file for a patent. Here is the fee schedule. A provisional application filing fee can range from $65 to $260, depending on whether you file for a micro, small, or regular business. For the utility patent and doing electronic filing, it can range from $70 to $280. It is dependent on whether you file for micro entity, small entity, or just regular. If you feel overwhelmed, you can always hire a patent lawyer. Typically, their initial fees for consultations can range anywhere from $300 to $800. Thank you for tuning in.